our learnings from Tuesday about this defence of self-defence. As I mentioned to a few of you when you came in, after the mid-semester break, Lucy's going to be back with you to finish off some more defences. So you'll look at some new defences with her after the mid-semester break, and then carry on with the rest of the content for criminal law, and then I'll be back with you in your very final week later in October to do some exam revision with you in the lecture and then in the workshops. Okay, so I get to come back at the end of the course, which is really nice. Okay, so what we're doing then today is looking at some of those interpersonal violence offences that are non-fatal, non-sexual that we looked at when we first started together at the start of this term, and then bring in this self-defence and practice self-defence. I was saying to some students I've seen this week to go over some feedback on their test, and I was saying in criminal law, once you've got your formula and you've worked out the kind of steps that you need to take to prove the elements of an offence or prove the elements of a defence, then you're fine, right? You've got it, because you can use that formula for any kind of fact pattern that comes up. So I know it's a little while away to be thinking about revision, but as you're going through these topics like interpersonal violence offences, defences, property offences you're going to look at with Lucy, party liability, as you start to do all these topics this semester, try and kind of break it down into the kind of key elements that you need to be going and working through logically for the offences that you learn about, and then for the defences, right? Because I think if you've got that, then you're fine, because you've got your safety net for any kind of fact pattern that comes up in front of you. Okay, so today we're going to be building our knowledge around starting these defences, and in particular self-defence. So we've got a question here that pulls in some of that earlier learning on interpersonal violence offences and then brings in self-defence. So again, we will do some work in groups. So brilliant to see most of you in a position to be able to work in a group or to a person next to you. That's neat, because it's a great way to keep learning and asking questions and working it out together. That's totally the point of these workshops, so that's neat to see. Okay, let's have a look then who we've got. We've got Andy. Andy is drinking in a bar with a friend Bob, and Andy drops his beer glass, which shatters, but the bottom of the glass is still intact, but it's got the shards of glass sticking up. So whilst Andy is taking the broken glass up to the bar, Vern, who's another person at the bar and is really drunk, bumps into Andy, and Andy gets angry as he nearly cuts himself on the glass, and he says aggressively to Vern, "What the hell, mate? Watch what you're doing." Okay, so then Vern sees Andy standing there with the broken glass and the shards of glass in his hand, and he thinks Andy is about to glass him. So Vern then picks up a bar stool, smashes Andy on the side of the head, knocks him to the ground, and then Andy is trying to crawl away and trying to stand up to get away from Vern, and then Vern hits him again, and this time hits him unconscious. Bob, the friend, says to Vern, "You better watch out, I'm going to get you back for this." So Vern then freaks out as he thinks Bob's going to come after him. He goes out of the car park, Vern jumps into his car, he's heavily intoxicated, drives home, and then just outside his house, stopped by the police, breathalyzed, he's over the legal limit. So here we're told, aren't we, what he's been charged with. So he's been charged with a section 189. He's been charged with a section 202C. In relation to being over the legal limit from terms of the intoxication level, he's been charged with section 56 of the Land Transport Act. We haven't covered it, but it's in there just to prompt a question around the self-defence. So you don't need to work through the elements of section 56. You just need to think about whether you could raise self-defence in relation to that driving charge. So what I want you to do in your groups is work through the legal elements. So by that I mean the actus reus mens rea. Work through the legal elements of the offences, so the 189, the 202C, and then think about whether or not you think Vern can raise a defence of self-defence to the 189 and the 202C. And then also have a think about, could he raise self-defence in relation to the driving charge under the section 56 of that Land Transport Act? If you work through that in your groups, probably about 15 minutes. It's taken groups a little while today because it's a longer problem question, kind of going through the law and then applying it. So if we maybe do 10, 15 minutes, we'll see how we go, and then we'll come back into the bigger group. If you've got any questions as you're working through, just let me know and I can come round to the groups. But otherwise, have fun, get going, start working through Vern's liability, and importantly, that self-defence. gone through it? How are you going with time? A little bit more time? Yep, okay. Okay, shall we come back then into the big group and start working it through? Okay, so remembering self-defence is one of these formal substantive defences. So it's engaged once you show that someone has already done the offence, right? Got the actus reus, mens rea, and then you can think about, is there an actual defence that can be argued, okay? So where did you start in your groups when you were working through? What did you first look at?
Was there an offence committed in the first place?
Yeah, good. Okay, excellent. So was there an offence committed, and which one did you, where did you go next?
We started with intent to injure, so section 189.
Yep.
And we looked at subsection 1 and subsection 2.
Perfect.
We evaluated that subsection 1 would most likely not be satisfied because the intent for grievous bodily harm is quite a high threshold.
Mm-hmm.
So we turned to subsection 2 and said that would most likely be satisfied because he did have the intent to injure Andy. He hit him over the head with a chair.
Mm-hmm.
And there was a reckless disregard for the safety of others because there was a reckless disregard for Andy's safety, but also the safety of the people around him, for example.
Yeah, okay, yeah. So, and how do we think about recklessness? What's recklessness again as a subjective mens rea state? Yeah? Perfect, right? The conscious taking of an unjustified or unreasonable risk, right? So I know there's a risk and I carry on regardless, right? So perfect to be picking up that it's subsection 2 is the most likely to be engaged. So there you have the mens rea covered off. What's the actus reus that's required? Injures, yeah. What do we think about as injure? Yeah, yeah. And what is injure? What's another way of talking about injure? How do we define injure in section 2?
ABH.
Yeah, actual bodily harm, yeah, which is more than trivial and
Less than serious.
less than serious. Great, yeah, perfect. In the class before me, I didn't even have to finish the question, someone jumped in. It's going to be so ingrained in you, right? These things, okay, perfect, right? So we've got injure, section 2, actual bodily harm. This is more than trivial, but arguably less than really serious, although obviously up for the jury, right, to decide. But so he's got the actus reus, he's got the mens rea. You correctly, I agree with you in your identification of it being the subsection 2. What was really perfect about what you did in your analysis is that because the question just said 189, you prompted it and went through and explained why you chose subsection 2 and therefore why you didn't choose subsection 1, right? So that was perfect, okay, because it shows your marker that you have an understanding of the difference between subsections 1 and 2, okay? Perfect, great. So in terms of that's the law, in terms of application, do we think he meets the actus reus mens rea? Can someone talk me through that? Nice and straightforward. Thank you.
I would say at the very least, by picking up a bastard and scratching someone in the head, you are running a very real risk of injuring. Like you don't care about the safety, you're like running a really real risk of injuring someone.
Yeah, good, right. So there's a conscious taking at least of an unjustified risk, yeah. If not the intent to injure, right? Was my aim, my object, my purpose to cause that result. Yep, when I picked up the bar stool. Great, okay. So I think he meets the elements of 189 subsection 2. What did you do when you worked through section 202 capital C, which was the assault with the weapon? What did you look at for that offence? What are the elements of 202 capital C?
An assault.
Yeah, perfect, right? An assault. Do we have an assault here?
Yes.
Yep.
And then uses anything as a weapon, and I think it's pretty clear that he picks up the bar stool with the intent to smash it on the guy's head.
Yep.
Makes it pretty clear he uses it as a weapon.
Yeah, perfect. Let's go back onto the assault to begin with, right? Because as you say, that's at the heart of a 202 capital C. What are the elements of an assault? How do we know that? Where do we find them?
Application of force to person another.
Yeah, good. So the application of force to person another is our actus reus, our mens rea is? Yeah, intentional, right? Intentional application of force, person another. What statutory provision defines those elements of an assault? Perfect, section 2, well done. Okay, excellent, right? The idea is if we just keep building these blocks, right, by the time you get to see me again in your revision week, it'll be just rolling off the tongue, right? It'll be so second nature to you. Okay, so we've got, can someone then, we've got the legal elements set out for the assault. Can someone just use the facts a little bit to do an analysis of that assault? So just using the facts, just use it into the actus reus mens rea of that assault. Thank you.
We're applying force to the person of Andy by picking up the bar stool with the intent which he did to injure him and intentionally.
Yeah, so we don't, great, right? We don't need to think about injure because it's just that it's not about the actual bodily harm, it's about the application of force, yeah? But by picking up the stool and then hitting him across the side of the head with it, he has indirectly, actually, hasn't he? Because he's used an object, but he's indirectly applied force to the person of Andy, and as we've said, he's done so intentionally. Perfect, right? Okay, deliberately, intentionally, or at least, as you mentioned before, conscious of a risk, took that risk and carried on regardless. Brilliant. So we've got our assault, which is at the heart of the 202 capital C, assault with a weapon. What about this point where you said, like, it's obvious he's using the bar stool as the weapon, right? Does he have to be kind of intentional about the use of the weapon? Can he just be kind of a bit negligent or a bit reckless with it? Like, what's the standard around the using of the weapon? perfect. Anyone, and I know it's a while ago now, so I'm taking a bit of a long shot. Anyone remember the case that makes that point? Ah, perfect, right? Murray and police, right, is our High Court, recent case, High Court authority, that the weapon, the use of it while they're assaulting has to be intentional. Okay? Yeah, just being reckless with it is not enough. I think we can argue, can't we? There's enough to say it's an intentional use of the weapon here. Perfect. Right, so we've got our offence, right? We've either got a 189 or a 202C. In reality, he'd only be charged with one of those. They're most likely to go with a 189, right? They may even, for argument's sake, because he's been knocked unconscious, they could have even gone for a 188, right, of causing grievous bodily harm, could have elevated it. But in terms of the ones that you were asked to look at, we've worked through 189 and 202C. Perfect. What about then of this issue of self-defence? How did you start thinking about whether you could raise, if we were giving Vern guidance, right, we were his counsel, what kind of advice would we be giving him about his chances of raising self-defence for these offences?
I kind of dealt with the driving charge first.
Okay.
And I just, like, the first thing is the actual, does it reach the threshold of the defendant's application of force?
Yeah.
And to cut it short, there's that case that, I can't remember exactly what it was, I think it was Hocking and v Police, which just says driving away while under the influence does not reach the threshold of applying a force.
Yeah.
So I thought he was basically cooked on that.
Yeah, perfect, right? So if you, yeah, I'm just thinking when you're in practice, yeah, absolutely, right? Okay, so you're right to pick up that the first thing I want you to do whenever you think about self-defence is think about that, what we call that kind of threshold, right? That threshold question or criteria. Because before you even get any further into self-defence, you have to make sure we can get over that hurdle first, right? What is that, just more generically, so taking it away from the fact pattern, what is that threshold criteria or question? What is it about? What is it asking? Yeah.
Like, did they use force in the commission of the offence?
Yeah, perfect. Okay. So did they use force in the commission of the offence? And who's the they? Who are we interested in? The defendant. Perfect. The reason I want to kind of highlight that is that one of the things I read a lot at the end of a year, if there's a question around this sort of stuff, is people switching it around and thinking it's about the victim. It's not. It's the defendant, right? That's all we're interested in that sense is, did the defendant in the commission of the offence use force, right? And actually, most of the time in self-defence, they will have, right? It'll be obvious. It's just that, as I said to you on Tuesday, we have to kind of go through those categories about when it's not constituting force so that you understand when it won't apply, okay? And great, you picked up. So that the Section 56 of the Land Transport Act, which is the driving while he's been drunk, he's not even going to have a hope of raising self-defence because after Hocking and the police, they make it really clear that for driving offences, you can't raise self-defence. So as you say, that's it for him. He can't even, not even a starter, okay, for him. Okay, so you got that out of the way to begin with. Okay, excellent. So then what about our 189 and our 202C? Like if we engage that threshold question again, has he used force in the commission of an offence? Yeah. Okay, it's straightforward, right? In that case, by using the bar stool and what he's doing, he's using force. Okay, excellent. So once we've now got over our threshold for these other two offences, where did you go to next then in your analysis? Yeah.
Was he defending himself, so the evidence established in Bridget?
Yeah, great. Okay, so then you went to that Court of Appeal decision in Bridget. So we set out the kind of the legal elements that come out of Bridget to begin with. What are the three legal kind of elements of Bridget that you need to work through for self-defence? Yeah.
What were the circumstances as the accused believed them to be?
Yep.
In those circumstances, was the accused acting in defence of theirself or another?
Yeah.
And then was the force reasonable in the circumstances?
Yeah, that they believe themselves to be in. Perfect, right? See what I mean about as long as you've got your formula, you're okay, whatever fact pattern is in front of you, right? Because your formula is, I need to remember the threshold question, get over that. Have they acted in the commission of the offence? Have they used force? Once I'm over that, I jump straight into Bridger and I go through and I outline those three different elements. Out of those elements, some are viewed subjectively, some are used objectively. It would be worth in your legal part saying which are subjective, which are objective. So which are the subjective, objective bits of the Bridger test? Yeah, perfect. First two subjective, final one is objective. You will see in some of the cases when you read them that we talk about different limbs, so like a subjective, objective limb of self-defense. So when I was learning about self-defense, we talked about the kind of self-defense as being a hybrid defense because it's a mix of objective and subjective. All that Bridger really has done is just pull that subjective limb into a bit more detail, right, and split it into these two elements. So that's why Bridger's a really helpful place to go to and just go, right, first, what were the circumstances the accused generally believed them to be? Subjective. Secondly, in those circumstances, were they acting in defence of themselves or another? Subjective. And then finally, was the force used reasonable in the circumstances that they believe them to be in? The reasonableness brings in that objective, right? It's a really important part of self-defense because, of course, it's the objective, isn't it, element that's moderating the subjective. Otherwise, if self-defense was all subjective, it would be easy just to say, well, I thought I was being attacked and what I did therefore was in response to that attack, right? So the objective brings in that kind of moderating influence to make sure that whatever you thought the circumstances you were, which is your own honest assessment of them, how you responded, the force used, was reasonable, considered reasonable, objective in those circumstances. And the reason that that's super important is because self-defense results in a complete acquittal. So it turns what would be a criminal act into something that we say is justified. Right? Remember I started the lecture by going through that kind of conceptual, is it a justification, is it an excuse? Self-defense is one of those justificatory defences because it shows that what we're saying is you're still technically criminal in what you did, right? Because you satisfy the elements of 189 or 202C, but we are going to say that you were right to act in the way that you did. We said you are justified. And because of that, we will then give you an acquittal if that was the case. Okay, so that objective part of the Bridger test is really super important. Okay, so let's look at the first bit. Okay, let's look at the circumstances that he believes himself to be in. What do you think the circumstances were that Vern believed himself to be in?
He saw a guy carrying, broken shards of glass.
Yep.
He had bumped into him, and then he was yelling at him
Yep.
while holding this glass, and he feared that he was going to get blasted by it.
Yeah. Yeah. Does it matter if the rest of us might look at that and go, well, he was only holding the glass, there's no evidence on the fact he was raising glass towards him, and kind of get into how real the threat was? Is that relevant? Yeah, that's right. Yeah. So it's a subjective test, right? So it's his perception of the circumstances that we're bothered about at this stage. Great. Yeah.
And also Vern is noted to be quite drunk, so
Yep.
that has to be taken into account. He was drunk, he just saw glass, someone had been aggressive towards him, so yeah, I agree.
Yeah, excellent, right? So the drinking, the intoxication can be relevant, can't it? Because it's a subjective assessment, right? It can be part of a subjective assessment. Perfect. So there was a case of Simpson in the Crown that makes it really clear that intoxication can be a relevance into the subjective part of the test. Because it's subjective, we're bothered about the honest, genuine belief of the defendant. So you can be mistaken. So even though he might have misread the threat, for the subjective part, that's okay. Can even be an unreasonable, as long as it's a genuine belief, because obviously the more unreasonable it is, the less likely the jury will believe him, right? But you can still have an unreasonable, mistaken belief because it's all subjective. Okay, perfect. Okay. Do we think then that in terms of the second part of Bridger, in those circumstances, do you think he was acting in defence of himself? Like, do you think he meets that requirement to show that he was reacting defensively?
Says on the facts that he's like thinks that Andy's about to blast him. So
Yeah. Yeah. It doesn't appear that it was in for any other motivation other than reacting to a threat that he thought was coming at him. Yeah, absolutely. So I think he meets that criteria in Bridger for showing it's acting defensively. Why do we think we have this criteria? Like, why do you think it's important for us to be thinking about, was someone actually acting in self-defense or?
Go out and just like shoot someone and say, oh, I thought he was like, you know, like you have to actually feel like you're being under threat.
Yeah. Some evidence that can be raised about your circumstance. Yeah, absolutely.
Would this step also allow context to be put in for like because it's a subjective test, so if you know someone has a history of like violently hurting people and they threaten you, it's more threatening than if someone you don't know does it.
Now that would be relevant for that first bit too about his assessment of the perception, right? Because it's subjective, as you say. Yeah. Did anyone else have anything they wanted to add?
Would this also like take into account like I think it was mentioned on Tuesday, like the preemptive strike stuff.
Mm.
Like this is taken into account like, you know, if they're gonna get like attacked tomorrow.
Yeah.
Does that take into is that at this step or is that at the third step?
No, I mean, if it's going to have any relevance in the way we deal with it in New Zealand, it's at this sort of step. Yeah, it's in that subjective awareness of what you thought the circumstances were, right? So that's where cases like, a lot of those cases dealing with family violence have been trying to push it forward, right, to show that someone's subjective, honest assessment of the risk that they face will be different perhaps from someone outside looking in who doesn't know the context of that violence. Yeah, absolutely. But that's all part of the subjective bit. It's also getting at the fact that, I don't know, say Vern and Andy had the argument the night before and then they're back at the pub the next night and Vern sees Andy and remembers that Andy was, I don't know, shouting at him the night before. Vern can't then just pick up the bar stool and whack him over the head, right? Because he's annoyed and vengeful and I'm going to get to you kind of stuff, right? I've remembered, I've stewed on it all night, right? And now I see you again and bang, I'm going to hit you because of it, right? It's a way of making sure that actually the person was actually, in fact, acting in self-defense, right? There was a threat there. There wasn't just a kind of premeditated or retaliation. Okay, it's the important part of the step. Excellent. Okay, then finally, this kind of objective part then, that kind of adds in and tries to rein in, I guess, the subjective part of the test. How do we, from that Afamasaga case, how do we figure out whether or not the force was reasonable in the circumstances as the defendant believed them to be? What are some of the criteria that we're looking at and how did you apply that then? I know. I realise I've done it in every single workshop. You'd think I'd remember not to flip the slide over, right? But humour me, right? When you were looking at these elements, how did you then apply them into the fact pattern? Yeah.
We looked at whether the force that was used was proportional to the threat.
Mm-hmm.
So the idea of getting glassed and then hitting someone with a chair is relatively proportional because glassing someone can blind them, like it has serious long-term effects.
Mm-hmm.
So in that case, we did say that that was reasonably, you could say that that was a proportional
Okay.
response. Then we looked at whether or not it was necessary to respond like that. In that case, there was a little bit of like uncertainty, at least I was uncertain, because he made no attempt to actually like attack him or like make any kind of threat.
Mm-hmm.
He simply just said like, can you watch where you're going, essentially?
Yeah.
And yeah, it was said aggressively, but you know, however, if you consider from his perspective, so
Yeah.
from I can't remember his name now.
Vern.
Andy.
Yeah.
If you
Oh,
consider
yeah.
no, not Andy, the other one.
Vern.
Vern, thank you. If you consider it from Vern's perspective, he probably would have seen it as a necessary response because he did feel like he was being threatened in that situation, so it would be reasonable to say that that was satisfied as well.
But in this part of the test, we're not thinking about it from Vern, right? We're thinking about it from a reasonable perspective, right? So we're having a different lens come down onto it, yeah. So good to be thinking about necessity, right? It's an important part of the working through the whether something's reasonable, but just making sure that it's the reasonable person as opposed to the defendant. Yeah.
I had a slightly different take, specifically in terms of like proportionality.
Yeah.
I think the
Hang on
first
a
part of
minute.
the
Sorry. Guys, can we just have attention? Yeah.
the first part of the attack I agree with. I think like hitting that I guess could be seen to be proportional.
Yeah.
But the part about on the ground, I thought like that is a demonstration and a use of force. That was definitely
Yeah.
not proportional to the threat. If he's on the ground and falling away, he clearly poses no threat, which means hitting him again with the bar stool is not a proportional response. And the other thing I think it fails on is the retreat.
Yeah.
I think there is a pretty clear option to just, walk away, especially after the fact that he's on the ground.
Yeah.
So even if it would pass the test, the retreat test, at that first stage of when he just hits him first,
Yeah.
after the fact he's already on the ground, I think it definitely fails then. It's definitely unreasonable then.
Okay, so you're making that distinction between the first hit and the second
I still
hit,
think he
yeah?
could get done on that first hit, but doesn't.
Yeah. But it's a lot more likely on the second, yeah, that he won't be able to raise it. Yeah, good. Did you have anything else at the back you wanted to add?
Oh, I was just thinking about the same part.
Yeah.
When you're assessing like self-defense, and then there's like, because the event itself can like be multiple actions. Do you like assess it holistically? So, like he was saying, after he was already on the ground and he continued to act in self-defense, that was excessive. That would negate everything.
Yeah, so so they will look at it sort of holistically, but you're right to both of you to be thinking about does my inquiry around necessity, imminence, retreat, proportionality, does that differ once the guy is starting to move away and he gets hit again? Do you know what I mean? Like, yeah, absolutely. I think it does. It certainly. I'm not sure that a jury would buy into it even on the first scenario, but then as you say, broken glass we need more detail, right? Because broken glass can cause huge serious harm, but there's no evidence it's coming towards him, or we'd have to weigh that up. But even if we went for it, even if we were saying to our client, it's more likely once he's knocked him unconscious, right? It's going to be very unlikely that any jury would think that that would be proportionate because the person's walking away or crawling away.
We said that the second hit would satisfy section 62, which is the excessive, being criminally responsible for excessive force in the
Yeah.
action of self-defense.
Yeah.
So like he was, as was said, he was already on the ground. He was no longer posing a threat. He was trying to get away.
Yeah.
So it's just not reasonable to say that the second hit was at any point in time a necessity or
Yeah.
like even that there was a threat posed in the first place.
Yeah. Yeah. Brilliant. Yeah. Good. Yeah. Excellent. So work through, right? Work through those. The way we think about reasonable, right? Whether the reasonable force was used. Work through proportionality. Work through necessity. Work through. There isn't kind of any duty as such to retreat, but there is this understanding that you can stand your ground, right? You're not required by the law to retreat, but obviously if you have options available to retreat, then that's part of the assessment about the reasonableness. And then the imminence, right? This was the thing that we talked about right at the end of the lecture. One of the really strong things that's still in our application around self-defense is imminence, right? Was he facing an imminent attack? Which is why when, as you say, the crawling away really negates up against that imminence, like you guys have been picking up. Yeah. Yeah.
I just had a question about section 189. Would you be able to argue that Vern did intend to cause grievous bodily harm just on the basis that he was using an object to hit Andy in the head? That doesn't seem like we can intend to just run a risk, or just intend to cause actual bodily harm, since hitting the head can cause like way more than serious damage, can be permanent and stable.
Yeah, and I think that the key point about working out whether it's 189 subsection 1 or 2 is just thinking about as much as you can, trying to get into the head of him, right? To figure out what was he intending, right? He obviously caused what actually could have been seen as grievous bodily harms. That's what I'm saying. We could have charged him, say, with a 188, right? But the intent bit in the 1891 and the 1892 is about what his intention is, not about what he's actually caused. So that's another thing that we see a lot of, is that kind of blurring of that. What's really important is whether you're saying he intended to cause really serious harm at the moment he hit him round the head with the bar stool, not actually whether he did cause that really serious harm. And for me, that's where the distinction would be. I'm not sure there's enough to say that in the kind of explosive kind of someone coming at me, he had an actual intention to cause grievous bodily harm, as opposed to just being at least reckless or just intending to injure. Do you know what I mean?
Would you use case law as, like, for this point to, like, distinguish that?
You could do it, though. Be very careful to make sure the case law you're using is on the law bit, not on facts, right? We don't want to be analogizing by facts. We want to be looking at what the legal principle is that we can use and apply. Yeah. The key thing also too is reading the question, and it's fine for what you're engaging with, because the question was about 189, and so what you would be doing there in those comments is working through an analysis to try and argue whether there is sufficient on the facts to try and show an intention to cause grievous bodily harm. In this sense, it would have been okay to come with a decision that it's a 189 subsection 1, right? As opposed to a subsection 2 like we went down. That would have been okay, because the key part of it is that you were showing that it still had to be an intention to cause grievous bodily harm, right? So as long as you made it clear that you were focusing on his subjective intention to cause that level of harm, then that would have been fine, right? Because it would still engage the discussion around self-defence. Yeah, perfect. The key thing is you're showing you understand the difference, which you are. Yeah, perfect. What about somebody in the other classes, they were talking about, like, in terms of proportionality and stuff, the fact that he's used the bar stool to hit the guy around the head. Like other people said, he could have done it to hit the guy's hand or something, to knock the glass out of the hand or something. Does that come in, did you talk about that in your groups? Like the fact that he's aimed for the head as opposed to other parts of the body? As you say, going for someone's head causes much more serious injury.
It's also way more likely to disable them in the immediate
Mm-hmm.
term. So if you're worried that someone's going to like hit you, if you just hit them in the stomach,
Yeah.
not necessarily in the stomach, just like stabbing you right after that.
Yeah, okay. Yeah.
In this case, would you apply like Palmer, where in the instance you couldn't exactly like weigh the proportionality in that instance? Maybe he didn't mean to hit his head, but just in general it happened to his head.
Yeah, fantastic, right? So that Privy Council case is an old case now in the 70s of Palmer, but that is a useful case in terms of when instructing juries, they're making it really clear this is not an exact science. This isn't something you can weigh up, the kind of like the threat someone's facing to the kind of the level of violence they use back. It isn't that kind of exact nicety as they talk about in the Palmer case, and that's important to raise, right? We acknowledge the fact, juries are told to acknowledge the fact that the defendant was in this kind of moment where they thought somebody was threatening them. It isn't a nice, calm moment of deliberation, right, that self-defence is dealing with, yeah. And that impacts, doesn't it, the understandings are proportional and necessary and things like that, yeah. Excellent. Yeah, really good point. Okay, well done. So did we think then if he was our client, as you say, we know there's no chance on the Section 56 because of the land transport, because it's involving a motor vehicle. What would we want to kind of just sort of summing up, what would we want to advise him around his chances of self-defence on these 189 and 202 say?
Very low.
Very low, right? Where do you think the big sticking block is going to be then, or stumbling block?
That second hit.
Yeah, the second hit. Yeah, yeah, the one that made the guy unconscious. Yeah, good. Okay, excellent. So again, as I said, like I've been saying to a number of students, I know I'm repeating myself now, but if you're finding, if there are some of the parts of the course that are more challenging in terms of offences, and now we're moving into defences, start breaking them down, right? So in the same way that Lucy helpfully did when we used that diagram, right, for our homicide and breaking down 160 subsection 2, do the same for these other offences and defences, because I think it just gives you a way in them, because it takes the, obviously the fact the surprise, right? But if you've got the formula sorted, whatever your formula is, then you can apply it to the facts in front of you.
Just a question about the four conditions thing. Would they be
Yeah.
considered elements or considerations in the sense?
Yeah.
Do all four need to be met for it to be found to be reasonable?
No, that's a great question, right? They're just considerations. They're ways in which we will advise a jury to think about what's reasonable force in the circumstances. Yes, it's not a and if you, it's not like a fatal if you don't meet one of those points. They're just things to consider to try and expand what we mean by being reasonable. Yeah, fantastic. It's a great question. Yeah, it's a really important point. Whereas the bridger, the 3 points in bridger, they are an and, right? You've got to do 1 and 2 and 3. The Afamasaga kind of trying to the Court of Appeal, trying to give us guidance as to what reasonable force in the circumstances means. These are just conditions that could be met, right? Ways of thinking about it. Yeah, it's a great question. Okay, have a good mid-semester break. Good luck if you've still got sentencing to go. And as I